Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. The majority of FCA investigations are into the healthcare industries, and there's a bunch of reasons for that. But mainly it's because healthcare is a huge chunk of federal government spending, and there's so much uncertainty in healthcare on what's okay and what's not. And when there are investigations into healthcare, there's often going to be patient information involved. And that's where healthcare providers start getting very nervous about HIPAA, and for good reason. The healthcare industry is well trained to care a lot about patient privacy. And so I'm never surprised when a healthcare client asks, how are we supposed to comply with both a civil investigative demand and HIPAA? And so on today's podcast, we're digging into the two. We're talking about a new case where a company has flat out refused to give DOJ any patient data, and that's resulted in DOJ seeking court intervention. So we're going to talk about all of those things. We're talking about CIDs and HIPAA and that case today on the podcast. Joining me to talk about these issues is my Husch Blackwell colleague, Claire Postman. Claire is one of my favorites in the firm. Claire really does care a lot about healthcare, and you could tell in her work. Claire studied public health in undergrad, and she just brings a wealth of institutional knowledge of how healthcare works when she's counseling clients. And it's always in a way that I personally find super valuable. And so I'm thrilled that I've finally convinced Claire to come on the podcast. And so Claire, thanks for joining the podcast and telling our listeners a little bit about the intersection of FCA investigations and HIPAA.
Thank you so much. That is such a kind introduction, Jonathan, and it's great to be here.
All right, Claire, let's start with the basics. So I think people generally know that HIPAA gives patients certain privacy rights. You know, if you go to your doctor can't take a picture of you and your medical condition and then turn it into an Instagram reel. I think that's not okay, and I think people get that. But there are some times where those covered by HIPAA can reveal protected health information. And one of those times is when law enforcement serves the legal process. So Claire, tell our listeners about why that is and just how all of this works.
That's exactly right, Jonathan. So HIPAA's privacy rule is the best known part of HIPAA. It's the rule that says that healthcare providers, covered entities, cannot disclose protected health information to other people. That's the general rule. It does have some important carve-outs. So, for example, most healthcare providers are very familiar with mandated reporter laws. So those are the laws that require them to report if they have a reasonable belief that a patient is being abused or neglected in certain instances. HIPAA obviously has an exception that's going to allow providers to make those reports, even though that technically does involve disclosing PHI to somebody outside of the provider. Another example is what you just mentioned, responding to some kind of legal process from law enforcement. So HIPAA does allow disclosure in responses to things like a court order, a grand jury subpoena, or, as we're very familiar with, a civil investigative demand, or what we call a CID, that comes from the Department of Justice in a False Claims Act investigation. So if a healthcare provider receives a CID that says, you have to give us Fred Smith's medical records, that's not a real person's name. I'm not violating HIPAA by saying that. The healthcare provider can generally do that and not worry that they're violating HIPAA because there is an exception to responding to CIDs. That said, there are some limits on that exception. So the first is that you have to be responding to what is actually in the CID or the subpoena, what's actually being requested by the government. So if the CID is asking for Fred Smith's medical records for a healthcare visit that happened on November 11th, HIPAA doesn't permit the provider to give up all of Fred Smith's medical records, including visits that happened not on November 11th. The second, the CID should be specific and limited in scope in light of DOJ's purpose for issuing the CID. Lastly, there are some situations where de-identified information should be produced if DOJ's purpose can be accomplished with that de-identified information, as opposed to the protected health information itself. So it's important, given all these exceptions, to confer with experienced counsel if you're responding to a CID. But the general point is that HIPAA does allow healthcare providers to comply with these legal documents, with subpoenas, with CIDs. Last exception that I'll mention to HIPAA, there is an exception for producing information to health oversight agencies. Most providers are most familiar with that in the context of audits. So when CMS requests records as part of a UPIG audit or a CPI audit, or if you get a subpoena from a board of nursing because they're looking into one of your employees. This exception for health oversight agencies does allow providers to respond to those requests. Some courts have also recognized and explicitly said DOJ is a health oversight agency when it is investigating alleged Medicare fraud or alleged false claims.
Thanks, Claire. That's excellent analysis. So I think you're 100% right. You said something that I think is really important, which is to consult with lawyers. When you're doing this, the last thing you want to do is violate HIPAA. I think it'd be sort of interesting if you did violate HIPAA by responding to a CID and then DOJ comes and goes after you for violating HIPAA for complying with what they asked for. But yeah, I think it is important for you to consult with people who know what they're doing. There is a special process when you're dealing with certain types of substance abuse records, for example. Part 2, you need a special court order. I've had to tell DOJ before, I'm sorry, I really want to give you these documents. I also don't want to get in trouble with Part 2. Congress at one point was looking into how DOJ was looking into substance abuse records in Part 2 without getting court orders. So there's all these reasons why you should just consult with a good lawyer. And also, like Claire said, Fred Smith, we just made that up. So I don't want to see a Fred Smith on my caller ID trying to call and say, what do you know about me? We're really just picking a name there. So thanks, Claire, for clarifying that. But Claire, as clear to me as the law enforcement carve out to HIPAA is, I was surprised how often I heard from healthcare providers that they couldn't respond to my subpoenas or CIDs because of HIPAA. And I was generally understanding of that. Healthcare providers, they don't get subpoenaed all that often and they want to protect their patients' information. But once I sent them a copy of the regulation, they realized, okay, I'm allowed to do this and I'll comply. And yet, Claire, there was recently a very public example of one healthcare provider that just flat out refused to provide patient information in response to a CID. And this healthcare provider is Kroger, the grocery store chain that I loved as a kid before Publix showed up to Georgia. But I love Kroger, specifically here, Kroger's pharmacy. So Kroger received a CID from DOJ in 2022, and for 3 years just refused to give DOJ any patient information, resulting in what is now a very public court dispute over whether Kroger is required to respond to the CID and tell DOJ about patient information. So, Claire, tell our listeners about Kroger's CID and why there's now litigation over Kroger's refusal to turn over patient information.
Yeah, so as a disclaimer here, we're relying on representations that were made in federal court filings. We don't have any behind the scenes insight into this case. But what happened here is, so typically DOJ doesn't announce or publicize CIDs. So when a provider is responding to a CID, most people don't even know that there is an investigation going on. But when either DOJ or the provider is subject to the CID, has to get a court involved, then everything becomes public. And that's what happened here. So DOJ served Kroger with this CID back in 2022. Their investigation is related to whether Kroger made false claims related to opioid prescriptions that Kroger dispensed. And Kroger starts producing documents in response to this CID, but in those productions, it's redacting certain information, certain patient information. DOJ then tells Kroger to reproduce everything without those redactions. And from the court filings, it looks like Kroger refused. Their rationale for refusing was that they were worried about accidental breaches if they started producing patient information that could result in financial liability to Kroger. They were also worried that they would be setting a precedent that if they produced this information to DOJ, they would be required to turn over patient data to other law enforcement agencies that might not have as robust security systems as DOJ has to protect patient data. So Kroger tells DOJ, no, it's not removing its redactions without a court order. So DOJ goes ahead and seeks that court order. And now DOJ's investigation is out in the open because the court is involved. DOJ is seeking to enforce its CID and get Kroger to respond. Kroger then files another response. And this one, I think, is where it gets really interesting because they're getting into those exceptions that I talked about earlier. And so what they're saying is that, sure, there is an exception for responding to CIDs, but it requires the CID to be limited in scope and specific to what DOJ is looking to address. And Kroger's position is that this CID is too broad. It's asking for information for 40 Kroger pharmacies. It's asking for data from 40 Kroger pharmacies. It's asking for every controlled substance prescription for each of those 40 pharmacies, regardless of who wrote the prescription. And so Kroger is saying the HIPAA carve-out for CIDs only authorizes disclosure when the CID is limited in scope, when it's specific. There's also a question of whether the health oversight agency exception applies, separate from the exception that's specific to CIDs. And if it does it have the same limits as that CID-specific exception? Do you have to produce de-identified data if that's feasible? Does it have to be specific and limited in scope if it's a health oversight activity? So now a judge is going to decide whether Kroger is required to turn over the documents unredacted, including all of the patient information that DOJ wants or not, whether they are permitted to respond with these redacted records.
Thanks, Claire. Excellent summary of what's going on in this case. And I think in general, Kroger's making some valid points here. A lot of CIDs that I've seen are really broad. This one seems really, really, really broad. All controlled substance fills for 40 pharmacies, regardless of who was prescribing them, whether it's a suspected pill mill doc or not, they're asking for a lot. So I can see where Kroger would say, this seems like something that we're not allowed to do given the law, and we want to comply with the law. So it seems like what they're doing is legit to me because this is broad. And so I think this is a case worth watching, Claire, because this could change how the healthcare industry needs to approach HIPAA disclosures in CIDs. So this is definitely a case worth watching. And so, Claire, maybe sometime next year we'll do a follow-up to this with an update because this is something that does come up because healthcare providers do get CIDs a lot. And this could be a game changer depending on how this comes out. But to me, Claire, what concerns me for Kroger is that there are two big risks here. And one is that now this investigation is in the public domain. So that usually only happens if there's a settlement or a lawsuit filed, or if the company has to disclose something for, an SEC filing, something like that. So Kroger has suffered some reputational damage here that it may not have if this never ended up in a settlement or something. So that's one risk. The other risk that I see is that DOJ may view this as petty or meritless or borderline obstructive. And you actually do see this in some of the more recent filings from DOJ in this case. You could tell that they're a little frustrated in this. So, Claire, I'm a firm believer in zealously advocating for our clients, but I'm also a firm believer in picking your battles. And that's because DOJ has a ton of power and can just wreck people and businesses when they want to. So DOJ has the ability to do our clients favors, like confirming closed investigations or offering cold comfort letters, things like that. But DOJ also has the ability to go in the other direction, like pushing OIG to exclude or imposing a CIA or pushing CMS to implement a mid-investigation payment suspension. That's a topic that our colleague Brian Nowicki told our listeners about on this podcast a few months back. And so, Claire, working with DOJ, at least to me, working with DOJ is really important. So, Claire, close us out by telling our listeners about how we draw that line between zealous advocacy and also not needlessly poking the bear.
Yeah, I think there's kind of 3 points to address here. First is being candid with our clients. So legal strategies that come with the risks you mentioned are always going to involve a conversation with our clients so that they understand what those risks are and can make an informed decision about how to proceed. So you mentioned payment suspension. That's something that could literally be life or death for providers who mainly receive reimbursement from government payers. our clients need to understand what the likelihood is of that outcome, whether that outcome has been imposed against other providers in their situation. And that's where experienced counsel really can help and say, hey, we don't really think DOJ is going to do that in this situation. Or actually, a provider just like you, when they did that, DOJ pushed CMS to impose payment suspension. In other cases, the potential benefits to our clients might be worth the risk of fighting back. So that's why having a conversation is always, always key. Second, negotiation with law enforcement before getting a court involved can make a big difference. So in many cases, we can have an open dialogue with the government to understand, what are you really looking for here? And I've done this a lot. I mentioned those kind of board subpoenas from boards of nursing. When they're phrased quite broadly, often we can go to them and say, what are you really looking for here? We want to help you. We just want to make sure we're using our resources wisely. And we're able to come to an agreement with them about how to narrow the scope of that subpoena, of that court order, in a way that protects our clients and their patients, but also doesn't jeopardize our relationship with the government. So working things out collegially while still accomplishing our clients' goals is best case scenario, because we get our clients what they want, but we maintain goodwill with the government, which generally, as you mentioned, benefits our clients given how much power the government has in these cases. And then finally, if it looks like things are heading to court, I think it can go a long way to explain your reasoning to the government, to mention that you really do want to comply with the subpoena or the CID, like you mentioned when you have these Part 2 cases, saying, hey, I really want to comply, but in this case, I just need a court order. So if you're Kroger, you explain to DOJ that you're not asking them to seek a court order because you're being petty or difficult or any of those kind of words you mentioned earlier. You're not trying to slow down the process, but you have genuine concerns that producing these documents might subject you to HIPAA risk. And in those cases, you assure the government that you want to comply, you're going to comply as soon as you get a court order, and you just need some additional assurance. Now, it does seem like Kroger did maybe do that. We don't know. And we don't know kind of where their relationship stands with the government now. But I think that's important so that they know that you're not at least just trying to be difficult for the sake of being difficult.
Thanks, Claire. Yeah, no, I 100% agree with everything you just said. I think these are really interesting points where we've got to, exactly what you said, Claire, talk to our client about the risks. Talk to our client about the risks and the benefits. What might happen if we try to make sure that we're complying with HIPAA? And what might happen if we just say, all right, it's a gray area. Maybe we should just give DOJ these records and read broadly the HIPAA carve out. Having that conversation with the client is going to lead to really the best outcome. I think not having the conversation with the client and just inviting all of this risk that they don't know about is not the way to go. And so, yeah, Claire, the big takeaway here is have the conversation. Have the conversation with your client before you start angering DOJ and getting them to a spot where they're filing enforcement actions. DOJ really does not like filing enforcement actions. And so, Claire, like I said, we should do a follow-up on this. So I'm going to put you on the spot and make you agree that we'll do a follow-up on this sometime next year. Deal?
I'm in.
Excellent. Excellent. To close, there's a whole lot of interesting stuff happening with the False Claims Act right now. We're at a bit of a watershed moment in terms of where we're going. There's some interesting kickback cases that are coming soon. Zafarov's going to be argued before the 11th Circuit in about a month. And so we're going to continue to bring you content on this podcast about those developments, because I think a lot of our clients want to know, how are we getting ahead of risk areas? What can we be doing right now to put ourselves in a good position so that if we are investigated one day, we know what's coming and we've clarified what we need to clarify right now about what we think the law is. So we're going to continue to bring you those types of discussions on this podcast. But thanks for listening to this discussion about this new Kroger case and HIPAA. We hope you found it valuable. And as always, if you have questions, feel free to reach out to us. But short of that, thanks for listening, and we'll see you next time.